Hi everybody and welcome to Module 6 for Psychology in the Legal System. Last week in Module 5 we talked about the juvenile and the civil courts, and I just wanted to say what a great job you guys did on the discussion questions. I was really impressed this week. I just wanted to make a few comments before we move on to this week's material though. Last week we talked about two questions, and the first was what was the proper role of the attorney in the juvenile court. So should attorneys act in the same role that they do in adult courts, or should they be more paternalistic or take on a more paternalistic role when they're working with juveniles? And the second question was with regard to preventative commitments. With regard to the first question, I think you guys did a great job of representing both sides of these points of view. I have to say, as an attorney, I think one thing, and as a clinician, I think the other. So in law school, we're taught that our proper role as an attorney is to do what our client wishes, as long as the client is competent to make that decision. And next week, we're going to talk a bit more about competency and what that means. But as long as they're competent to make decisions in their case, we should help them, but the ultimate decision is theirs to make. And our job is to assist with the strategic matters and to figure out how these goals are going to be accomplished, not what the goals are going to be. However, as a clinician, I have to admit that I've seen some juvenile attorneys that are more paternalistic, and I've seen the outcomes of some cases that I really thought were probably the best outcome for the child, even though they had adopted a more paternalistic stance that kind of goes against what attorneys are taught in law school. So great discussion on that question. I also wanted to address some of the issues and questions that were brought up in the preventative commitment discussion. The first thing I wanted to talk about is the difference between prediction of dangerousness and assessing for risk. So you guys are quite right. We're actually not great at either one. But in the field, rather than talking about prediction of dangerousness, usually people talk about it in terms of assessing risk. So we can assess risk, but we can't really predict whether someone's going to be dangerous. We can only assess the risk factors that that person may or may not have. So you're right, we're not great at it. And we do have some tools that are out there, and the tools that are pretty specialized because each population has its own risk factors and its own specific concerns. So you'll see one specific to domestic violence, you'll see separate tools that are for sex offenders, etc. And I think some of you noted that they're not often used in clinical practice at times, and that's usually because they were developed for research, but there's another reason behind that as well. There's also a divide in the field about how best to do risk assessments. The first, one of the ways that some people think it should be done is without clinical judgment at all. So just using actuarial tools, and by that I mean just looking at static variables of the person. So variables that don't change over time, but that we know are associated with either increased or decreased risk for a certain behavior. And people in that camp think that it's best to leave clinical judgment out altogether, and that really these models are going to do best predicting on their own without us mucking around with them. And then other people think that there should be a larger role for clinical judgment. However, there's some research that shows that we actually make our risk assessments worse by including our clinical judgment in them. So some people think that clinical judgment on its own is fine, and other people think that we should have guided clinical judgment where a tool might have a certain outcome, for example, but we can still override that if we know certain factors. So for example, if you were looking at only static risk factors, someone's risk for committing sexual assault might continue to be high just looking at the static factors that are included in the assessment instrument, but then you may know something about that person that would greatly decrease that risk, like that they now have a severe disability and there's no way that they could commit that kind of crime anymore. So those are all just things to take into account, but the most important is that to think of reframing the issue in terms of assessment of risk rather than prediction of dangerousness. But again, great discussion. You know, I think you hit the major points, is that we want to protect people's civil liberties, and that's really important to do. And at the same time, it's a difficult decision to make because we want to be able to balance public safety against that. This week, we're going to move on to a discussion about some of the more criminal-focused areas in the legal system. And I focused this week's lecture on the case law to help you guys contextualize it. This is a bit of case law that I think doesn't make sense out of context and can be difficult to read without that context. So for the death penalty cases, I've tried to lay out a history for you in the lecture that you can read through and contextualize some of those cases. And I've done the same thing with the cases regarding the form and limits of expert testimony. So I hope you guys find that helpful. Bartol, I think, does a good job of discussing the rest of the materials. However, at the end, I did want to make a few comments about places where I thought he could have better represented wider points of view, for example. But good luck with this week's materials, and I'm looking forward to seeing you all next week.